Evening, everybody. Welcome to another live episode of The Breakdown. I'm your host, Nate Pike. It is May 24th, 2026. Oh, do we have a show for you tonight? We've got the depth. We've got the nuance. And we have to start with a bit of an apology, actually. A little bit of a mea culpa, apparently, for those of you who follow the show regularly. You probably know. Last week, about 10 days ago, we made the announcement that we were, it's been a year or two. It's been a little busy. There was the lawsuit, and then the injunction, and then the more lawsuit, and then more drama and politics, and then I sued a couple people, and I'd love to be able to talk about that tonight because there were some fascinating developments that are tangentially related. But in the face of all of that, we decided, you know what? We're going to take a little break. We're going to take a breather. We're going to take a week and a half, maybe, off. And on behalf of everybody involved with the show, I would like to sincerely apologize for that. I never for one second thought that the breakdown would say, hey, you know what? Let's take a break, everybody. And the province would say, what if we did a referendum on separation instead? Sorry, I that's all I've got. I don't know what to say other than sorry. Bunch of big announcements coming tonight for those of you that have made it to the 7 o'clock start. Yeah, we changed our start time. We're going to be doing that going forward for a long list of reasons. But we're going to be doing 7 o'clocks on Sunday. Got some other exciting announcements about some new things we're going to be trying over the summer. Beta testing, if you will. And then some other things that we're definitely going to be doing over the summer that you maybe want to be in the loop for. We're saving that for the end because there's this whole referendum on a referendum. We were originally going to go with like a Harry Potter themed graphic. But who would have thought that the author who wrote a story about compassion and inclusivity would ruin that story by being dispassionate and not inclusive? So instead, we went with the vacation theme. We try to. Anyways, graphics are hard. We got to talk about the referendum business. And what we're hoping to do tonight is something a little bit different because we are only going to be talking about one thing. I know. I bet there's a lot of you that think I can't do that. I can. It's a personal challenge I've issued to myself. We're going to talk about just one thing tonight because it's important to understand that the pathway to this referendum is long and fraught and extraordinarily complicated and disingenuous and manipulative. And in order to try to explain all of that in one shot, because this is going to be a conversation in the province of Alberta, we want to try to do everything. Bam! Here's everything you need to know about how we got here and what the history of democracy is in Alberta. It should be fine. It should be fine. I'm sure I won't screw this up at all. But let's get into it. Because for a lot of people who are wondering, there's going to be people who are wondering, what is a referendum? What is this whole separation business? What is all of that? Let's try to make some sense of that tonight. And in order to do that, we have to talk about the functional and foundational pieces of this conversation that are really, really important to understand. Because there's some misrepresenting you'll see as we go throughout the next hour and a half, hopefully, he said cautiously. In regards to the type of democracy that we have here in Alberta and Canada. At its core, what we're supposed to have in Alberta is a representative democracy. Now, you can get into the constitutional monarchy. We're not talking about that. We're not talking about that. We're purely talking about how people cast their votes and what they're casting their votes for, and the differences between the two major systems. So don't worry, we have infographics. It's going to be fine. But there are two broad categories that need to be compared and contrasted in order to understand the conversation around the referendum stuffs that are happening. The first type is a representative democracy, which is where you elect an official to go and do the things. That person's job is to go in and talk to the smart people for you because you've got to get the kids to baseball practice or to sports, or you want to do other things with your time other than learn nerdy levels about constitutional law and supervised consumption sites and all of those things. If you just don't want to do that, that's what you would elect an official for. The official is supposed to be your representative in the body that makes all of the rules, decisions, and laws. Now, the other type, broadly speaking, I'm going to get DMs on this. I know this is all broad. Bear with me. It's going to be an hour and a half. If y'all keep interrupting, it's going to be a lot. The other type of democracy is a direct democracy. Now, this is the type of democracy where people vote directly. So you don't have a representative that you say, hey, Timmy, I got to get the kids to baseball practice. Would you please deal with this for me? You're casting all of your votes. And there's some big differences between the two. Cue the infographic. So in direct democracy, all eligible citizens vote directly on laws and policies. The citizens vote on issues frequently, often issue by issue. Now, here's where it gets challenging. Decisions are made by the general public, who may have varying levels of knowledge about complex issues. So when you're talking about really, really complex issues where a higher level of knowledge or even some expertise is required, this is where direct democracy really starts to fall apart. But where it gets really, really, really problematic has to do with something called the tyranny of the majority. Majority rule can override the interests, the rights and interests of minorities. In representative democracy, it's not perfect either. Elected, as we're seeing in the province of Alberta, some might say, elected representatives make decisions and pass laws on behalf of the citizens. Citizens vote for representative periodically. Example, every 4 years. In Canada, it's mandated every 5 years. You have to have an election every 5 years. Representatives can specialize, deliberate, and rely on experts and information before making decisions because they're supposed to be making the best decisions possible for the electorate. And there are built-in protections, constitutional rights, rule of law, and elected officials help protect minority rights and liberties. And that last piece is super, super, super important because without constitutional rights, without the rule of law and the judiciary, then it's very, very easy. And history is littered with tragic examples of where the majority has said, well, we are the majority and we don't like that kind of person. So we're just going to get rid of them one way or the other. And if the decisions are being made by the majority and that is the only recourse that's available, then anybody who's not in the majority is in a lot of trouble. So having constitutional protections, having the rule of law, all of those sorts of things are extremely, extremely important. So let's just start with that. We're going to make that step one. Now, the next thing that we got to talk about is the history of separatism in Alberta. And arguably, it goes back to Alberta in 1905. There will always be people who are displeased with the state of things, who jump right to the easiest solution is going to be, what if we just went about it on our own? There's no shortage of examples of those. But one of the things that's happened over the last couple of weeks, months, and years has been the framing of Alberta separation as being a relatively new phenomenon. It's a relatively new thing. It's that 10 years of that Justin Trudeau is why we're wanting to separate. It's only been 10 years. And that's actually unbelievably inaccurate because we've got this guy. This is Gordon Kessler. He was elected. I'm not even joking. In 1982, as a separatist, he ran in a by-election as a separatist, and he won in that by-election, running for the Western Canada Concept Party. He won, beating the Social Credit, the Progressive Conservatives, the NDP, the Liberals, and the Independents. The Independent did not do well. He got 9 votes. But he ran in Olds Didsbury in the by-election, and Gordon Kessler was elected to the Alberta legislature as a separatist. So separatism in Alberta goes back A very, very, very long time. It's been a long time that we've had the separatism in Alberta. We have elected MLAs as separatists. The first one in 1982. Who would have thought it would take 40 years to elect the next one? But here we are, nonetheless. So, let's get into how we got to where we are with referendums, because referendums actually go back farther than people realize, but they also don't go back as far as people realize. Referendums in Alberta, direct democracy, only goes back to 1992. That's really it. It was introduced in 1992 with Bill 1, and even then was limited to questions of only constitutionality, and it could only be initiated by government. So there was no direct democracy where a citizen could say, hey, I would like to raise my hand and say whatever thing bubbles up and see if I can whip people into a fervor over that and, I don't know, destabilize entire economies. There was no mechanism for that, possibly because it's very bad to do that sort of thing with some of the things, especially when there's no limitations on it. So that was it. That was the only mechanism that there existed for referendums in Alberta until June 17th, 2021. And that's when we got the Citizen Initiative Act passed by none other than Mr. Oh gosh, did I just set the drapes on fire? Jason Kenney. And it's important to realize that when we're talking about the act that Jason Kenney put in, it was a populist move. There's no question about that. But it also had some sort of built-in safeguards to some degree, a little bit, because I think that even Jason Kenney recognized that if you just open up the doors and let any fool raise their hand with any dangerous idea, the fools will raise the hands with the dangerous ideas. And so there was some structure that was put in place. And when we're talking about the structure, there were 3 different types of proposals that a citizen could initiate. The first one was a legislative proposal. So this is asking the government to create a law. The second one was a policy proposal. And the third one was a constitutional referendum proposal. But where the safeguards really got into place had to do with the numbers. So looking at those numbers in the case of a legislative proposal. So if you wanted to say, I believe that we should outlaw cheese, you should not do that. Cheese is wonderful. Don't hate on the cheese. But if you wanted to outlaw the cheese, you had to have at least 10% of the total number of electors. So the total number of people who were allowed to vote in the province at the time of the last election, you had to have 10% of that number. In the case of a policy proposal, you had to have 10% of the total number of electors entitled to sign those signatures each. In this case of a constitutional referendum proposal. So you want to do something that asks the provincial government to try to fundamentally change the Constitution of Canada or violates the Constitution of Canada. Let's say that you wanted to do something that would require the notwithstanding clause. You have to have 20% of the electors in the province. So that's what Jason Kenney brought forward. Good or bad, mostly bad. But there were no initiatives because the bar was too high. And that's a good thing, because if you're going to open up those doors for direct democracy, which has a lot of cons, then you should have safeguards in place. You should have guardrails in place. But then came the federal election. Nope, that's not the federal election, although I bet somebody really wants it to be. That's the federal election. Mark Carney won a minority government, beating out the Poilievre. Mr. Poilievre lost his seat. Justin Trudeau had already not run, so that was easy. And then Jagmeet Singh also lost his seat in that election. Huge upset. And since then, the federal Liberals have done a very, very good job of bringing people in and building themselves a nice little majority government. That happened on April 28th. On April 29th, the very next day, the province of Alberta, the government of Alberta, under Danielle Smith's direction, introduced Bill 54 on April 29th. Almost as if it was in someone's back pocket, just in case the Polyev, he did not win. There are people who might suggest as much. Nonetheless, here we are. And this brought in some major changes in regards to how citizen-initiated referendums could be initiated. Now, before we get into the nuts and bolts of what changed on this particular piece, because there's several where they made changes, before we get into the nuts and bolts on this particular piece, though, it's important to emphasize that there has been, as part of Danielle Smith's trajectory, her arc, she embraced a lot of the separatist rhetoric. She embraced a lot of the separatists. There were a lot of people who supported her rise to leadership who were really, really excited about Danielle Smith being the Premier of Alberta because she was going to fight back against Ottawa. She was going to bring in her Alberta Sovereignty Act, which gave us a bulletproof shield to stop any federal laws, even though it turns out it doesn't work that way. She was going to override COVID restrictions by ambassadorizing planefuls of tourists to Florida as ambassadors to give the diplomatic immunity, even though not a thing that a premier could do. She made a lot of promises to a lot of people, and a lot of those people were a little bit more on the extreme side of the right. Jason Kenney made comments about the lunatics taking over the asylum. He had real concerns about that. So it's important to highlight that when we're talking about the direct democracy piece, when you have even the vaguest of awareness that you have elements of your base that are perhaps a little bit, what's the word I'm looking for, feral, perhaps making things easier for them to be feral all over the province is not the greatest choice. But nonetheless, that's exactly what Danielle Smith did, which brings us to our second fancy infographic, because this highlights the changes that Danielle Smith made with Bill 54. So the first thing is she lowered the signature threshold, particularly on constitutional initiatives. So it was, prior to that, 20% of all eligible provincial voters. Instead, it got dropped down to 10%. But that's not the only significant change that was made in regards to how those voters were counted, because instead of making it the people who voted, the total number of voters in the province, instead of making it the total number of voters in the province, it was now based on how many people cast ballots. And when you consider that the province of Alberta has a 60% to 70% turnout on a really, really good election, that is a huge decrease. So not only are you cutting the entire body down by 30 to 40%, but you're also saying of that 30 to 40%, you now only need to get 10%, which is a big deal. She also extended the signature collection time from 90 days to 120 days. And she opened the doors for unions and corporations to contribute to referendum and, air quotes, direct democracy campaigns. Some pretty big changes. And a lot of people looked at that and was like, oh, you're trying to make it so the separatists take a grab at that brass ring, aren't you, Danny? And a lot of people had a lot of big concerns about it. And one of them happened to be former Deputy Premier, PC Minister of basically all the things, Thomas Lukaszuk. And this is where, again, we've had some retconning of history that we need to sort out a little bit, because there's been some dishonesty, there's been some disingenuousness, and we need to talk about those. On June 30th, Thomas Lukaszuk put forward his policy initiative. Now, it's important to realize that when we're talking about the policy initiative, it's literally a policy initiative. When we take a very, very close look at the document that Mr. Lukaszuk submitted, it's very clear he was reading the tea leaves, because there's two types of petition that you could select: a legislative or a policy proposal, or a constitutional referendum proposal. This is under the old rules, so it was determining the number of electors that you had to get. He chose, the check marks there for anybody who wants to see it, a legislative or policy proposal, which requires signatures from 10% of electors on the post-election day list. So that's what he chose. Now, there's layers to this that require a little bit of unpacking in order to make sense. At that point in time, there's a group of separatists who had already come forward and said, as soon as these new rules come in, we're in like a dirty shirt. we're so going to get our 177,000 signatures and we're going to separate from Canada and it's going to be the best day ever. That was well established. So it was reasonable to assume at that point in time that there was going to be some sort of a citizen initiative question that was put forward. Writing was on the wall. But it was also very clear. And even going back to the reporting of the day, this is a news article from, I'm looking at June 30th, 2025, literally the day that Mr. Lukasik submitted it. And if we read how his submission was described in that news article, at the same time, Thomas Lukasik, a progressive former conservative deputy premier in Alberta, is working to thwart that separatist effort. Lukasik, now out of politics, argues that Alberta's rules do not allow for two competing petitions on the same issue. There's only one petition at a time, so mine precludes theirs. On Monday, Elections Alberta approved his application to undertake a petition for the province to declare its official policy to remain within Canada. Since Lukasik applied before the new rules took effect, he'll need to collect 294,000 signatures, but he says he's confident that enough Albertans would sign their name. So, everybody knew at the start that it was a policy question. The strategy that Mr. Lukasik was deploying by putting forward those questions was twofold. Number one, by choosing a policy or a legislative piece, he forced the government to make a choice down the road. We're going to get to that in a sec. At the time, the legislation was very, very clear. You could only have one citizen-initiated referendum on any given topic for a period of 5 years. That was the rules of the day. So when Thomas Lukasik pulled the trigger on this, he had every reason to believe that by putting forward this policy that would have to be decided on by government, he didn't have any say in what they did with it, and we'll get to that in a sec, that he was blocking the separatists from getting their petition. And so everybody who signed up knew they were signing up, well, maybe not everybody, the vast majority of people who signed up knew they were signing up, A, to block the separatists from putting forward a question, and B, for a policy proposal. And as I said, we pulled up, it took like 30 seconds of Google searching to find a news story that literally said exactly that. So what are the duties and responsibilities? We could do the really fine print version. This is from the actual act, from the actual time that his policy proposal was submitted. And what it basically says is, in the case of a legislative proposal or a policy proposal, within a certain amount of time of the government receiving the copy of the legislative proposal, 15 days, and within 10 sitting days, they have to have referred a motion to a committee. And that committee then decides, okay, what are we going to do with this? Either we're going to table a report recommending that the bill be introduced at the earliest practicable opportunity, or the policy be accepted at the earliest practicable possibility, or table a report recommending that the initiative petition and report be referred to the chief electoral officer for holding an initiative vote. So that was the rules of the day. By putting forward a policy or legislative proposal, it then goes to the government. The government then forms a committee, and that committee goes, should we vote on this as a legislature, or should we instead kick it as a referendum? But where it gets to be really important, where the nuts and bolts get to be so important to be highlighted, this is from the Elections Alberta website. They literally put a note under each of the proposals on their FAQ for what happens. The petition proponent does not direct or determine what happens after the petition is submitted. The committee will determine the outcome. And they put that note on both the legislative proposal and the policy proposal. So there's no arguments to be made that the decision on what to do with a legislative proposal or a policy proposal rests with the committee. So Thomas doesn't get a say. He can collect all the signatures he wants, but he doesn't get a say in which road they choose. And in all transparency, the times that we've had Mr. Lukasik on the show, and it's been a couple now, he's been very clear about that. He's been very clear that his original goal was to force the government to choose between voting in the legislature or being responsible for pulling the trigger on a referendum themselves. And he's been very, very clear that his goal from day one was to try to block the separatists from putting forward their proposal. But nonetheless, the APP did, in fact, put forward their proposal. They put their proposal forward on July 4th. And this is where it starts to get a little wild, because within 30 days, somebody putting forward a proposal, the Elections Alberta CEO has to make a decision about, does the question meet the required parameters? Is it allowed to be a question? And to be clear, the rules at the time were pretty light. It was basically, you can't breach the Constitution on a constitutional questions. You can't breach sections 1 through 35. You can't do that. And that's about it. And having the inclusions of section 1 through 35 is actually really, really important when you stop and think about it, because that's where all of the personal rights live. That's where your right to have your religion exists. That's where your right to be who you are without persecution exists. That's where your right to not be illegally searched and seized and detained exists. So guarding those is really, really important. And as we've learned in the province of Alberta, the only way that you can override any of those rights is by using the notwithstanding clause, which Danielle Smith did a great job of doing with teachers. I could get beside the point. But the important part of all of this is that on July 28th, the Chief Elections Commissioner referred the question to the courts to determine if it was valid, and a full hearing was scheduled. Now, in the meantime and in between time, there's another little piece of video, audio for our audio listeners that I just want to throw in here because it is relevant and it is important. Because one of the questions that exists is, how do we deal with binding referendums versus non-binding referendums? A binding referendum is a referendum that says whatever the results are, even if you don't like them, you absolutely have to follow what they are. Kinda. A non-binding referendum says, we're taking your pulse and whatever. We're going to do what we want anyways. It's more of a performative thing. And this question around binding referendums was explicitly asked of Danielle Smith going all the way back to July 12th.
This is going to be a citizen-initiated petition, and we already do have a citizen-initiated petition that has been affirmed by the elections official. He has agreed to consider the "Do you want to remain in Canada?" as a question, and that is if he can get the requisite number of signatures, that would be the one that goes to a ballot. So I'm allowing that process to play out. All right. Thanks for your call, Wayne.
Would that be a non-binding question?
It would be. I think you have to look at the legislation, but my intention would be that I respect the will of the people. I don't think Albertans are wrong, and so if Albertans decide which way if they want, first of all, want the referendum question, and second of all, if they vote a particular way, I would honor the results.
Let's be perfectly clear about something. Albertans can and absolutely have been wrong, because you've never had all Albertans agree 100% across the board. So by nature, if you ask somebody a question, one person has one opinion and another person has another opinion, and it is a balance of facts. Is climate change real? Let's do that one. That's easy. Is climate change real? The answer to that question is yes. There's a lot of Albertans that say no, but it's a scientific imperative. So there's some Albertans that are wrong. If you were to ask some people, I don't know, maybe premiers, I'm just hypothesizing, about chemtrails, most people would say, oh, that's just the water vapor that comes off the plane because of the high pressure that happens and the altitude and the cold and all that. It's really nothing to worry about. It's basically rain in the sky. It's making little clouds. But if you were the premier of Alberta, then you might say, well, you'd have to talk to the United States if they're spraying us with anything. Some people are definitively, demonstrably wrong. Period. End of sentence. It's that easy. So The idea that Albertans aren't wrong, that is a little bit of it's pitching. It's trying to use the words to make people feel really, really good about themselves. You can't be wrong. It's okay. It's populism at its absolute worst. And it's something that Danielle Smith is very, very good at doing. But there she said, even if it's a non-binding petition, non-binding, she will follow through on whatever the vote was, which is bonkers. It's absolutely bonkers. But we need to move on from there because there's more. It became obvious as the court process was going on with the separatists' petition, things they were not going so well. And so the UCP decided to introduce Bill 14. And Bill 14, the Justice Statutes Amendment Act, did a couple of different things in its introduction. The first thing that it tried to do was it tried to shut down the court proceedings that were going on about whether or not the question was the question brought forward by the separatists, not Thomas Lukaszik's question, but the question brought forward by the separatists, whether that question was even legal to ask under the laws. And so what Mickey Amory and Danielle Smith did is they got together and they said, what if we just changed the laws entirely before the court process was done? Then we could beat those judges because they have such contempt for them. Bill 14 introduced language changes. It changed the word applicant to proponent. It gave the Minister of Justice the final say on whether or not initiatives were similar to those in the last 5 years initially. The right of refusal. So instead of the CEO being able to say, yeah, you can't actually ask if we're going to get rid of anybody who's not white from the province, you can't actually ask that. You can't do that. The CEO no longer would have that power on his own. He would have to say, hey, Justice Minister Mickey Amory, you agree, right? And then Mickey Amory would go, yes, I agree. We should not get rid of everybody who's not white. This question will not be allowed. But the final say under the original proposal rested with the Justice Minister, which is a huge conflict of interest for a lot of different reasons. It removed the ability of the CEO of Elections Alberta to refer questions to the courts, and it removed the constitutionality requirement. So now, all of a sudden, we don't have to have that pesky Constitution getting in the way of determining whether or not a question should be asked. And again, this brings us back to the very big problem of if we don't have guardrails, if we don't have things that exist to protect minority rights, which are important. Shouldn't have to say that, but apparently it needs to be argued. If we don't have mechanisms in place to protect minority rights, the tyranny of the majority kicks in, and people who are not part of the majority just lose. Now, where it gets wild is the Elections Alberta CEO sent a letter being like, hey, this is a bit of a problem. Me having to refer all of these questions to you, it creates something of a conflict of interest that's going to be damaging of trust. So Mickey Amory, at the very, very, very last minute, amended the amendment. And when he amended the amendment, he took out the referral ability to the courts entirely. So now, it used to be, there was a mechanism to say, oh, I don't know about this question being legal or not. Now, doesn't matter if the question violates the Constitution of the Charter of Rights. Doesn't matter if it's wildly illegal. It's allowed, and there's no mechanism to prove otherwise. So, already, things are going wildly off the rails in regards to having guardrails to prevent that from happening. What are the fundamental changes that Bill 14 brought about? Well, remove the constitutional screening. They thought they could stop the court proceedings. The courts had some thoughts about that. We're going to get to those in a sec. Added election blackout periods, removed or added some timing rules for when referendums could happen. Brought in the increased through regulation, the application fee, and tried to reset the entire process. But The courts did not appreciate that. The justice who was hearing the question as to whether or not the constitutionality was legal, despite the promises that Mickey Amery made the day before, issued a ruling. Before we get to what the justice said, let's hear from the justice minister, who's also, by the way, a lawyer.
The idea here is that if we are going to move forward with this particular process, that we're always going to create again an opportunity for people to bring their important questions forward and do so without the hindrance of either the CEO or the government in doing so. We think it's important for them to be able to, or it's important for Albertans to be able to present questions to their fellow Albertans without the obstacles that we've seen in other scenarios. When it comes to, again, the question you've had about, maybe I'll continue with the question about Justice Feasby and the court decision. The amendments will create, again, sort of a renewal, I guess, if you will. The approved petitions will continue to proceed as they were, and the petitions that have not been approved will have the petitioners will have the opportunity to refile within 30 days at no additional cost. That is independent, I would say, of whatever the court decides in this particular issue. And the reality is that the court's entitled to make a decision on any question put to it, independent of what we're doing here. So I expect that the court process may or may not continue. That is somewhat unrelated to what we're doing here. What we're saying here is that those that have not been approved or referred to the courts will be effectively reset, and the opportunity for the petitioners will arise to resubmit again and move forward under the new rules. Again, I think I'll make it again abundantly clear. The people here in Alberta, those that have worked on the Forever Canada petition, for example, those that have worked on independence petitions, have expressed their concern with one petition piggybacking over another. And we think that these rules will clarify that for everybody. There is no intention to allow one to piggyback over another. And what we've heard is conversations about whether or not the Forever Canada petition is effectively a question of independence and separation, because the no's to that will signal potentially the Albertans' desire to separate. So we think that if we allow the process to proceed in the Forever Canada petition as it is, that a different petition will have to go through the same rigors and get those signatures that they need.
So simultaneous, possibly yes.
Simultaneous, sure.
Sure, let's have multiple referendums asking similar questions. What could possibly go wrong or be confusing, said Mickey Amery on December the 4th. And it turns out that apparently at Mickey Amery's behest, there was a letter sent to Justice Feasby, who is the judge, the justice, who was overhearing and justicing the question as to whether or not the separatist question was constitutional. And Justice Feasby had some words, because there's a little bit of chicanery. They introduced Bill 14, but there's still a process that a bill has to go through to become a law. And it requires multiple readings in the House. You can't really ram a bill through in like one day, technically, under normal circumstances, unless you're using the notwithstanding clause. You're not supposed to be able to do that. And so there were a few days. And on December 5th, much quicker than anyone expected, Justice Feasby issued his decision. And there were some really important pieces in that decision. We're going to talk about some of them right now. The first thing that we need to talk about has to do with the epilogue that occurred. And this is where the justice said unequivocally that he did not appreciate very much the efforts of Alberta trying to push through the act. Late yesterday afternoon, Alberta wrote to the court to advise that Bill 14, Justice Statute Amendment Act 2025, had just been tabled in the Legislative Assembly. JSAA 2025, amongst other things, seeks to amend the CIA, Citizen Initiative Act, to repeal Sections 2.3, which requires legislative proposals to be within the jurisdiction of the Legislative Assembly, Section 2.4, which is the section at issue in the present case, and Section 2.1, which gives the CO the power to start a special case to the court, as was done in the present case. The letter provides that any existing special case is discontinued without any costs to any party. Alberta's letter explains that once this legislation takes legal effect, the action will be discontinued. The legal consequences of discontinuing this proceeding prior to a decision would be to silence the court. Legislating an end to litigation is extraordinary. The proceeding continued today because JSAA 2025 has not been passed by the Legislative Assembly and proclaimed into law. The case remains a live controversy until JSAA 2025 is law. Further, there was no efficiency to be gained in declining to hear Blackfoot First Nations interveners who were ready to make their submissions. To refuse to hear the Blackfoot First Nations interveners who had worked under significant time pressure and incurred considerable expense to deliver evidence and written argument to the court would bring the administration of justice into disrepute. They asked for and were granted their day in court before Alberta decided to change the law, and it was only fair that they have it, regardless of the pending decision. So there's a little bit of angry being thrown there, as arguably well should be. But that was just the start, if you will, of the discontent from the justice, because he went on in his epilogue and pulled very few punches at all, really. In the second part, he said, to be clear, Albertan has the legislative authority to change the CIA, or the Citizen Initiative Act, as it appears intent on doing, but attempting to change a new law that was amended earlier this year after the many participants in the matter have made significant expenditures of time and money to litigate on an accelerated basis is contrary to the rule of law, which is not nothing. That is a fairly strong rebuke, if you will, of what was going on. But he just got started. Legislating to preemptively end. I'm going to jump back. The rule of law plays a critical role with respect to the democratic process, where the stability of the governing legal regime enhances legitimacy and public confidence in the outcomes of elections and referendums. Changing legislation to circumvent a valid legal process commenced by the independent officer of the Legislative Assembly responsible for administrating democratic processes is the antithesis of the stable, predictable, and ordered society that the rule of law contemplates and democracy demands. Legislating to preemptively end this court proceeding disrespects the administration of justice. Now, that's the rebuke that was offered up, the epilogue. I'm going to call it a rebuke because the judge very clearly said, y'all are messing around with things that I don't think you understand, and it is bad. It's bad for democracy. It's bad for the rule of law. It's bad for all of these things. Please stop doing that. But also, just to put the fine point on things, he answered the question as to whether or not the question was constitutional. Treaty rights are recognized and affirmed, not guaranteed, and they are incorporated by reference, not specified. These are distinctions without a difference. Perhaps an independent Alberta would adopt a provision like the Constitution Act 1982, Section 35, and recognize and affirm treaty rights, but for the reasons explained above. And this is the part that you're going to want to save for all your separatist friends. Alberta cannot succeed to the numbered treaties without the consent of First Nations. Moreover, this decision has concluded that the transformation of provincial and territorial borders into international borders would contravene the numbered treaties by significantly impairing the exercise of treaty rights by First Nations. So, and I've referenced this before on the show, but we're pretending that we're starting over for the purposes of this little chunk of the breakdown. Alberta cannot leave Canada without the permission of First Nations, all of the treaty signatories. They can't do it. So all of these separatists that are running around saying, oh, no, the treaties don't matter, we do it. It doesn't matter. It doesn't matter. A judge has already made the determination that in order for Alberta to begin the process of leaving Canada, you have to have the agreement of the treaty signatories, period, end of sentence. Because again, those treaties are not with Alberta. They're with the Crown. Alberta is not a party to the treaties. They are affected by the treaties. We live inside of the treaties, but you don't get to change them. It's like speeding laws. If I'm speeding on the road, I don't get to just say, I don't recognize your laws. I'm going to do what I want to do, la, la, la. Only the people who make the laws get to make that determination. So that's it. That's the ball game. But that was not something that people wanted to acknowledge or accept, because it ruined the bedtime story that they told themselves about how easy it would be for Alberta to separate. It also triggered a staggering amount of racism. And if your only argument that you have left after being confronted with reality is, well, I guess I'll just be racist then, that speaks not only to the strength of your argument, but the strength of your character. But moving on from there, Dani, she had some thoughts shortly after all of this played out. We're going to go to January 29th of this year.
I've always been clear that me and our United Conservative Caucus are supportive of a strong and sovereign Alberta within a united Canada. That is one of the bills that we passed when I first came in. But I think we also have to be realistic that 10 years under Justin Trudeau's government, our province was relentlessly attacked. Our economy was relentlessly attacked, not only for our economy, but our provincial rights and also our personal freedoms and our way of life. And so when you look at the polls, they suggest as many as 30% of Albertans have lost hope. That's about 1 million people. And I'm not going to demonize or marginalize a million of my fellow citizens when they've got legitimate grievances. What we need to do is we need to give Albertans hope. We need to show them, not just tell them, not just words, but with actions, that Canada can work. And that's what I've been doing. That's why I signed an agreement with the Prime Minister in November so that we could work in common cause on correcting some of the mistakes, I would say, of the Trudeau government. And it's why we participate in these kinds of First Ministers conferences, so that we can find the things that we agree on and work together for that, for the betterment of the country. And I think this is a very powerful table that has been able to do that for the last 3 years that I've been on it. And I'm honored and delighted to be here.
Danielle Smith on January 29th, 2026, making a very strong argument. You know, you can say things, you can use words, but it's your actions that matter more than anything else. It's your actions that really convince people of where you stand, what your values are, what you stand for. It's your actions that matter. If it seems like I'm belaboring that, I absolutely am. And we're going to get to that in just a few minutes. But before we do, one of the other questions, just a couple of days later that Dani was asked, is also particularly germane to this conversation.
There's also Justice Feasby, the Alberta judge, who said a day before you or the day after you introduced the new referendum law, he was already considering the question at hand, the secession question that the proponents have proposed. And he said that question would contravene the Constitution because it provides no guarantee of basic rights under the Charter, and because it doesn't sufficiently protect Indigenous rights because Alberta is not a party to the numbered treaties. You've already got a judge who has said that the question at hand wouldn't meet a constitutionality test. Does your Attorney General disagree? Does your Attorney General plan to pronounce on the constitutionality of this question before Albertans are asked to vote?
Well, I think we'd have to see, first of all, if they get the number of signatures, and then we'd have to see what the construct was of the Forever Canada a question as well, which is equally problematic, because if you're asking a question, do you want to remain in Canada? Yes, no. What does no mean? Like, I think you have to be very clear about what no means before you put it on a ballot. So that's another thing that the committee has to consider. But I'm going to let the process play out. What we wanted to do with Citizen Initiative is not have a bunch of gatekeepers prejudging whether something should or should not be asked. We wanted to see if something had enough expression of support, and then it's up to us to put forward a question that would be constitutional and to implement them if passed in a constitutional way. So no, that work hasn't yet been done by the Justice Minister, because we're waiting to see the result of the petition to see if it even does get the requisite number of signatures, and we'll know that in a couple of months.
I mean, can we just take a second? Can we just take a second to appreciate that clip is from March 6, 2026. The Separatists had first introduced their question on July 4th, 2025, which implies that for almost a year, the Minister of Justice couldn't find the time in his busy schedule to form an opinion as to whether or not their question violated the Constitution and the Charter. It seems like that should be, I don't know, I've never been a justice minister, never will be, but it feels like that should be a high priority action item. But the core of what Danny was saying there is that they would never allow a question that would be unconstitutional. They just wouldn't do it. And even if the question got answered and it was unconstitutional, that they would make sure that it was administered in a constitutional way, which is wild, given that she had just finished saying, well, you know, you got to be really, really clear about the Forever Canadian question, because, like, what does a no mean? And you got to know the answer to all that. But if somebody asks if we should separate Canada and that question's not constitutional, we have to find a constitutional way to implement it. It's just bonkers. But again, this is one of Danny's big gifts. She's able to word salad in ways that sound very, very convincing until you take a step back and go, wait, the math on those words ain't mathin'. But Mickey Amory also made it very, very clear. No unconstitutional question could ever appear on a referendum in Alberta.
The bill states specifically and unequivocally that any referendum question that offends sections 1 through 35.1 of the Constitution will simply not be allowed, Mr. Speaker. The division is absolutely absurd. The Act itself has a provision that describes the exact scenario that the member is posturing about. That will not happen. It is non-negotiable. Treaty rights will be respected in this province.
Given that a court has already said that the question is unconstitutional, and given the Premier said this weekend that her Justice Minister might amend the separatist petition question before it goes to Albertans, and given that this would be the first, second, third, fourth time in a year that the UCP will be directly intervening to keep separatism on the agenda in Alberta, and given that if the UCP writes the referendum question, it would be confirmation that separatism was never really a so-called citizen initiative, but actually a UCP government initiative. And given that most Albertans already believe the Premier herself will vote in support of separatism, why won't the Premier just admit that the UCP is a separatist government?
Once again, Mr. Speaker, the reality is that the signatures have not even been submitted. We don't even know if there is going to be a sufficient number of signatures to trigger a referendum in this province. Referendums are a citizen-led initiative, Mr. Speaker, but the reality is here. I'm going to say it one more time for all of the Assembly and all of our guests in this legislature. Any question that violates the Constitution, sections 1 through 35.1, any question that deals with a matter that breaches treaty rights is non-negotiable. It will not happen in this province.
Okay, so there we have Mickey Amory being very, very, very clear. He's using his big boy voice and everything, or close to it, that no question that violates sections 1 through section 35.1 will be allowed to appear on a referendum. That's the government's official position. It's the position of the Justice Minister. That should be taken seriously by all involved. I suppose, as if that wasn't going to fold like a cheap suit. I don't know what made me think of cheap suits right there. Anyways, moving on. It was very, very clear. No way, no how. There's going to be limitations. You can't have non-constitutional questions. It just won't be allowed. And yet, just a couple of days later, so that was March 9th. And on March 17th, after Mickey Amory said there's certain things that should never, ever, ever be allowed to be on a referendum, here's Danielle Smith.
The way the Citizen Initiative Act is written is it's meant to be permissive. It's meant to allow for citizens to identify an issue that's of concern to them and to bring it forward without gatekeepers, without us deciding they can't do it, or the elections officials deciding they can't do it, or a court deciding that they can't do it. If they get the requisite number of signatures, which is 177,000 over a 120-day period, then it will go to a process where those signatures will be validated, which is vitally important. We saw with the Forever Canada petition that there were some 50,000 signatures that were not considered valid. So that is important as part of the process. And then we will have an idea by June whether or not that is a valid petition that has collected signatures in the appropriate way. It's up to government to then, we have a committee that's looking at the Forever Canada petition. It's up to government to then put these forward on a ballot, and depending on what the outcome is, to make sure that they're implemented in a constitutional way.
And again, we have that doublespeak of if something blatantly violates the Constitution, it should be allowed. People should be able to put anything on a referendum that they absolutely want to, even though the government guy in charge of the justice system and is an expert lawyer, I'm air quoting, even though he just finished saying that no, absolutely not. Questions that violate the Constitution should be allowed. It gets to be very confusing. It's almost as if it's not about the same things that everybody says that it's about. And for all of those reasons, she talked about the committee. Don't worry, we're getting there. For all of those reasons, it shouldn't come as a huge shock that on April 20th, a judge issued, in effect, an injunction, a stay. And basically what it said was there are all of these court proceedings that are going on in regards to the legality of the question. A bunch of First Nations has stepped forward and said, hey, these questions are actually like super illegal and we're not on board and it violates the Constitution. So could you please do the judge thing and like get these guys to behave themselves a little bit? And a judge did issue a stay saying that while the signatures, the petition could complete and the signatures could be handed in, they could not be counted or verified until this whole thing was sorted out. Now, the other piece that we got to talk about real quick happened on March 30th, and this is Bill 23. I don't know why I keep thinking it's over there tonight. Bill 23. And this was another Justice Statutes Amendment Act. And in regards to what the Justice Statutes Amendment Act did, at its core, not very much. But what it did do was it implemented blackout periods for when citizen initiated referendums could happen. So in the period before an election of 1 year before an election, you can't have any citizen initiated referendum. And in the period 1 year after election, you can't have a citizen-initiated referendum. So you got 2 years in between elections, in the very middle, where you can do the citizen-initiated referendum, but outside of that, you can't. So there's that. And Mickey Amory's explanation for that was interesting.
I'm wondering about this blackout period for the citizen initiative questions. And what does this mean for when we could see referendums? Like, could we still see referendums between elections, or is part of this trying to line them up with general elections?
No, I think to the contrary. It's intended to create a period either 12 months before or 12 months after a general election where referendums could not be heard. And I think the idea here is to make sure that we don't have referendum questions operating at the same time as general elections or near this at the same time as general elections. What it will do is it will create a very clear and open window in between elections for referendum questions to be put forward to Albertans.
So would you rather, you would prefer to have referendum questions in between general elections, not at the same time?
I would prefer that to be the case. There's a lot of things that happen during general elections that I think Albertans want to hear about, policies, ideas, concepts of the various political parties during the general election. And there are important questions that are put forward by citizen-led initiatives in the way of referendums that I think deserve an audience as well. And the purpose of these amendments is not to commingle them or to create a scenario where they are operating at the same time, because I think that Albertans deserve to have an unfettered line of view on both of these very important issues.
Okay, so Bill 2023 makes the argument that there shouldn't be any referendums in between elections or overlapping elections because we need to have a clear line of sight on our elections. And this is where, again, the nuance matters, because in the Citizens Initiative Act, they added this piece saying that there cannot be any referendums for basically a year before and a year after a scheduled election. What do you do with snap elections? I don't know. Seems like a great way to put a referendum to end, but what do I know? But outside, you're either way. That differs from the Referendum Act. So there's the citizen-initiated referendum thinger over here, and then there's the Referendum Act, which is the government being able to do referendums. They've put this restriction on the citizen ones, and they don't have to follow it themselves as the government. So as a point of clarification, we spoke to a couple of folks, and it appears that we could have this referendum question that we're going to talk about in a few minutes, and we could have another referendum in 6 months if the government decides to call that election, because by asking the referendum question that we're going to get to in a couple of minutes in the way that they have, they've positioned it so that the government would then be calling the next referendum and can do so whenever they choose. That's very important to understand in regards to how dumb this is all potentially going to get. But without jumping around too much, the next major development came on the May 13th ruling. And that ruling was the ruling on the questions. So one of the questions was, can we get an injunction saying that all of this has to go on hold? The other question was, is it legal or not? And the injunction question was denied, and all of the separatists went, yay, we're going to have a referendum. And then the other part came down, and all of the separatists got very, very sad, because in that ruling, it was very, very clear that the government had completely crapped the bed by forcing the CEO, in effect, forcing the CEO of Elections Alberta to issue the question. From that ruling, I conclude that the CEO decision triggers a duty to consult. All three elements of the HIDA test are satisfied. The Crown has actual knowledge of treaty rights that are engaged by the second proposal. The CEO decision triggers a binding referendum on secession. Because of the sequence of events that are triggered by the CEO decision, the CEO decision constitutes Crown conduct. A requirement to implement secession without prior involvement of the applicants has the potential to adversely affect treaty rights. The CEO decision therefore triggers a duty to consult. It's the next part that is critically important, and you have to wonder whether or not Danielle Smith has read or she's just that comfortable lying to Albertans. I hasten to add that while the Crown's duty to consult is triggered by the CEO decision, there is no requirement on the part of the CEO to engage in consultation, nor does he have the ability to do so. The CEO does not represent the Crown for the purpose of fulfilling the duty to consult. Pause. The CEO does not represent the Crown for the purpose of fulfilling the duty to consult. New sentence. It is the government as the party that would implement secession that must engage in consultation. Again, it is the government as the party that would implement secession that must engage in consultation. Following the CEO decision, the amended CIA put into motion a series of required steps that engage the duty to consult with the applicants. No consultation occurred. The applicants, by the way, in this context, are the First Nations folks that said, you can't do this. Alberta breached its duty to consult with the applicants. So, the judge said the duty to consult is the government's job. Period. End of sentence. That gets to be really important for some of the clips that we're going to play in just a little bit here. But it didn't stop there. Alberta's application to strike evidence partially granted. They wanted to strike some evidence because they didn't like it. But here's the big part. Paragraph 245. The CEO decision is quashed on the following grounds. The CEO's interpretation and application of the transitional provisions, particularly section 71.1, bracket 1, was an error of law, rendering the CEO decision unreasonable. The CEO's decision not to reject the second proposal in the face of Sylvester was an error, rendering the CEO decision unreasonable. And the Crown failed to meet its duty to consult with the applicants, given the CEO decision is quashed on 3 grounds. I decline to consider the constitutionality of the impugned provisions. So, the judge said it should have never been issued. The petition should not have been issued. They should not have been, the separatists should not have been given the green light until the government, not the petitioners, the proponents, not the CEO of Elections Alberta. Once the question was brought forward and the CEO said, whoa, I think this might be the thing, it was the government's responsibility to engage in the duty to consult. It was the government's. And yet, none the less. Here's Danny.
We have to allow for citizens to be able to express their view on any issue that they like. And it's there's sort of a practical problem of when you talk about the law here, how in the world is a petition proponent supposed to meet that high standard? It essentially negates any citizen initiative, and that again is not what we would wanted with this legislation.
It's not the proponent's job to do the duty to consult. It's the government's. And it doesn't mean a veto, as much as some of us, like this guy right here, might wish that it did. It doesn't. The government has to do the duty to consult, and they didn't, and that's it. But Danielle Smith, who, if we remember back from a few clips ago, was all very much about it's your actions. Oh, it's your actions that show people who you are. It's not just your words, it's really your actions that carry. She had some actions that she wanted to announce.
Hoping you can explain how far you're kind of willing to go in this appeal. Like, I'm wondering if you're kind of willing to go to the Supreme Court, for example. Like, how far are you willing to push this rather than just call a referendum on separation yourself?
Well, I can tell you, I mean, we do have to appeal it because we did give the indication and we modified the citizen initiative referendum law several times so that it was very clear that our intention as the elected democratic leaders was to have a permissive approach. As I've always said, it is up to the elected people to implement policy in a way that is constitutional and in keeping with the law. But we have to allow for citizens to be able to express their view on any issue that they like. And it's there's sort of a practical problem of when you talk about the law here, how in the world is a petition proponent supposed to meet that high standard? It essentially negates any citizen initiative, and that again is not what we would wanted with this legislation. So I think that the duty to consult is an obligation on government, specifically when we're talking about the impact on treaty rights over hunting, fishing, trapping, and when we're dealing with particular projects. I think that part of law is very clear. This is pretty murky. That's why we think it may be incorrect and why we have to appeal it. And we'll see if there are other provinces that might be interested in weighing in on this as well, because it has the potential to impact them too.
And then what about the other reason for this decision that's not the duty to consult? It's most of Justice Leonard's decision is actually about Bill 14 from December, and this kind of timeline where Elections Alberta had denied the first proposal on December 8th. Bill 14 came into effect on December 11th, which therefore made the separatist proposal ineligible under the kind of transition period. Do you think that this decision is essentially a result of kind of the miscommunication between what the government's bill meant and wanted to get done and Elections Alberta?
Well, I'll let the lawyers deal with that, but my understanding is that what happened is that the group then resubmitted their question and restarted the process once our new legislation came in. So they restarted under existing legislation that we had modified. So I guess that's going to be a question for the court, and that's why we think it may have been incorrect in law, in part, and why we are going to be appealing it.
I mean, there's so much to play with there. The two things that I want to pull out of that particular clip, though, is if you can't imagine how putting an international border through the middle of multiple treaties could affect the ability of First Nations to exercise their treaty rights to hunting, fishing, and gathering, then you're suffering from a crippling lack of imagination. That much should be self-evident. But here's the other thing. Again, we go back to that line about how, they can put forward anything. We want to be permissive. We want to allow people to talk about anything they want to. If they want to put a referendum question forward, we should allow them to do that. And then it's our job, whatever the question is, it's our job to do that and implement that constitutionally to make it legal. It's so dumb. And here's an easy little thought experiment to show how dumb it is. If I was to come up to you and say, I really want to rob that liquor store, and you were to say, okay, let's do it. I've heard your voice. Let's say I have 3 friends with me. All of my 3 friends agree we should rob that liquor store. We have decided as a group, there's 4 of us and 1 of you. The majority has decided we're going to rob that liquor store. It is now your job to figure out how we're going to rob that liquor store legally. You can't, because you're robbing a liquor store. It's that dumb. But that's the line that Danny was very, very committed to, which brings us to the committee. And before we get into the committee piece, there's something that I really want to emphasize here. In all of the clips, a lot of the clips that we've played so far, there has been this continued commitment to democracy. We have to respect the people's wish. We have to respect the democratic process. It's so important to respect the democratic process. We got to respect the democratic process, y'all. It's so, so, so important. That is our guiding light. That is our North Star. In all of this complex stuff, we have to respect the democratic process. Let's get into it, because the committee piece is an important thing. So going back to Thomas Lukaszik's Forever Canadian question, the obligation, as we addressed earlier on in the show, on the government was to put together a committee to discuss, okay, what do we do with this now? Do we do the policy proposal? Do we vote on it in the legislature? Do we kick it to a referendum because we're cowards? What do we do here? And that committee was made up of 3 UCP members and 2 NDP members with a UCP chair. There we go. Okay, setting the stage here. That UCP chair is named Brandon. He's chair of a couple different things. We'll get to that on a later episode. But the timeline's a little, what's the word I'm looking for here? Fuckety. It's a fuckety timeline. And I say that because on March 9th, the order paper was submitted saying, hey, we should do this committee thing because we got the thing and we need to do the thing. And it was officially formed on March 10th with 90 days to complete their work. 42 days went between the formation of the committee and the first meeting. Now, that was all under the control of the committee chair. They did not have their first meeting until April 21st, 2026. They had an organizational meeting, proposal review, sort of like, hey, everybody, welcome to the committee. Finally, we're halfway through our mandate, but we've got time. No big deal. The next meeting was on May 11th, and that was a technical briefing with the Justice Ministry and Elections Alberta. The third meeting, you'll notice things seem to have picked up a little bit between the big deal court ruling and the rest of the time, because on May 20th, they had a deliberation amendment meeting where they heard from none other than the proponent after saying that they wouldn't. It's almost as if they were trying to manufacture a narrative, Thomas Mraiche, but Thomas was not, despite the fact that they very much treated him like he was a hostile witness. Like one of the UCP members, she was like, oh, but I have these social media posts that said the word referendum. I'm not going to acknowledge in any way the timelines or the overlapping referendums or the fact that we were moving the goalposts all over the field with the legislative changes. Despite that, Thomas really wasn't having it.
We had members of the UCP party and the NDP party and the former Reform Party and Liberal Party all working together to keep this province within Canada and to counter any potential threat that at that time existed, was an existential threat that the separatist question would go forward. This was a very coalescing moment, very community building moment. This was a moment where after a rather divisive period following COVID and convoys and other things, where again, neighbors were not always talking to neighbors, this brought them together. So it was a very unifying process. And the only goal of Forever Canadian and the petition gathering process was to avert the danger of having a binding referendum that will spark a process that could possibly lead to Alberta separation, but also to sideline the economic damage that this already is causing to our province. You know, Ms. Nancy Southern, the CEO of ATCO will tell you that. All major chambers of commerce will tell you that. So it was to minimize any negative impact on Alberta economy as well.
So that's Thomas Mraiche saying, look, we absolutely did not want a referendum. We were trying to prevent a binding referendum because we did not want to see that happen. We didn't want to see the economic damage. We didn't want any of that. And Thomas also made it very, very clear. If the UCP Majority Committee decided to go ahead with a referendum, that was not on him.
I do not have a legal standing of either permitting you to put the question to a referendum nor stopping you from it. If you choose to put any question you want to a referendum, you will be the proponent of a referendum on breaking up Canada, and you will bear all the consequences of that position.
Now, we're getting to the bonkers parts, because in the face of all of that, nonetheless, Nate Glubish, who was, not this Nate Glubish, who was sitting in for Rajan Sani, who didn't make this meeting, read out what was, I mean, the way that he read it. He's looking down at his little paper. He's reading his little question. That was very clearly scripted for him. And if it wasn't clearly scripted in that moment, boy, wait till we get what's coming next. Nate Glubish said, hey, but I think, democracy.
What I believe the right thing to do is, having heard what we've heard, is to give the 400,000 Albertans who signed this petition what they asked for when they signed this petition. And to that end, I would like to move a motion here. I would like to move that the Select Special Citizen Initiative Proposal Review Committee recommend the following. A, that the Alberta Forever Canada Citizen Initiative Policy Proposal tabled by the Speaker in the Legislative Assembly on December 2nd, 2025, Sessional Paper 241/2025, and the committee's report be referred to the Lieutenant Governor in Council for the purpose of a referendum in accordance with the Referendum Act. B, that the Alberta Forever Canada Citizen Initiative Policy Proposal be appended to the committee's report. C, that the question to be put to the electors in the referendum include an option for Albertans to vote for Alberta to remain in Canada. And D, that the referendum be held in conjunction with the referendum ordered to be held on October 19, 2026.
So Nate Glubish, the pinch hitter in this circus, is the guy who brings forward the very clearly, I'm reading from my piece of paper, and these are the things that I was told to say, is reading from that. He's the guy who introduces the motion to have a referendum on separatism right after Thomas Lukasik sat there with the support of the Forever Canadian people saying, we do not want a referendum. Please do not do that. This is on you. Nate Glubish, he had his script, and there was no like, oh, we don't. We want to respect the wishes of the person who organized all of this. The proponent, we're supposed to respect the way. No, my script only says that we do the referendum. Nate Glubish, for anybody who's playing the home game, is the MLA for Strathcona Sherwood Park. That's the kind of representation and democracy by script that you're getting from Mr. Glubish there, folks. Congratulations, I guess. But where the appearance, and it's wild because as Glubish was making his little motion, and the meeting is still going. So I want to be very clear for this next bit because it is in fact that bonkers. Nate Glubish has just finished throwing the entire province under the bus because presumably Danny or Rob told him to and gave him a piece of paper that he was supposed to read. And he's just the very best poodle, so he did. And then this happens.
I understand that the UCP have already issued a release about a referendum being called, and that's already been released to media. So a little awkward since we're still debating the motion, but perhaps that is because this committee has always been treated like a sham by the members opposite, who have also delayed significantly in even calling this meeting, although they cared so desperately about the 400,000 Albertans, but yet didn't want to hear from them.
You heard that right. While the meeting was still in session, there had been no vote. I mean, this is authoritarian theater taken to the next high, like most inconceivably high level. There is no vote. Nobody has voted. The UCP caucus released this press release where it says, for immediate release, Chair of the Special Select Citizen Initiative Proposal Review Committee, Brandon Lunty, issued the following statement on recommending a referendum question to Cabinet. The Select Special Citizen Initiative Proposal Review Committee, such a mouthful, established to review Thomas Lukasik. This is a quote from Lunty. Established to review Thomas Lukasik's Forever Canadian petition, has passed a motion that the Special Select Committee on Citizen Initiative Petition Review recommend the Government of Alberta include a question on October 19th, 2026 provincial referendum that includes an option for Albertans to vote to remain, for Alberta to remain in Canada. And then the whole press release is just basically the rest of him quoting what all of the process. This is what we're doing. And then it had some social media posts from a period of time taken both in and out of context, not all of which, by the way, were from Mr. Lukasik. For some reason, they also included posts from the NDP and others, as if that somehow substantiates the case that no, you really wanted this referendum, and we're going to give it to you. But they released this while the meeting was still going, and it got nutty because the parliamentarian for the opposition and NDP opposition, Christina Gray, she was there as an observer and as an MLA because of how egregious this was, how insulting this was to the democratic processes, to the legislature. Boy, did she have some words for Mr. Lunty.
I am interrupting these proceedings to call a point of privilege because I have just had the opportunity to review an absolutely shocking news release sent out already while this committee is in discussions that reads that the chair of the Select Special Citizen Initiative Proposal Review Committee, Brandon Lunty, issued the following statement on recommending a referendum question to Cabinet. The Select Special Citizen Initiative Proposal Review Committee, established to review Thomas Lukaszik's Forever Canada petition, has passed a motion that the Special Select Committee on Citizen Initiative Petition Review recommend the Government of Alberta include a question on the October 19th, 2026 provincial referendum that includes the option for Albertans to vote for Alberta to remain in Canada. It continues on with quotes from you, Mr. Chair. While we are debating this in this committee, oftentimes it feels like the politics of the UCP is a stage play to exercise their power to do what they want. But I very seriously raise this point of privilege now because it has been never more apparent than the fact that this committee is still meeting and still debating this motion, and a press release from you as the chair has already gone out.
It's bonkers. And yes, there is a comms person who sent that release out too soon. And yes, the UCP did have a majority on that committee. So there was never any real doubt that they were going to get what they want anyways. But it goes to, if the point of having a representative democracy is to allow for the best possible outcome, to allow for debate, to allow for all of those things that people expect from their elected officials, it doesn't mean anything to the UCP. They had their press release with quotes done before the meeting started, because Brandon Lunty, he didn't give those quotes during the meeting. So this was all authoritarian theater. This was never about having a conversation. This was about doing the bare minimum in order to get what they want. And it's really, really important to understand that, because Brandon Lunty, he's the one at the center of all of this. And where it gets really bonkers is the next, we're not going to do all the video because I'm not going to play the whole meeting for you, but the Coles notes is that when they came back from their little recess, they were like, this needs to go to the speaker. This is a massive point of privilege. Brandon Lunty was like, yep, sure is. Let's recess. And maybe let's just vote. Let's vote. What do you say we vote? Or maybe we can extend the meeting. Let's extend the meeting. Hey, everybody, let's extend the meeting. The trick to extending the meeting in order to do all of those other things, though, is you need unanimous consent to extend the meeting. And the NDP, they were not in a unanimous consenting kind of mood. So the meeting ended. They reconvened it the next day on May 21st for the final debate. Given that the UCP had already released their press statement and then, as to be expected, effectively re-released it the next day. They got together the next day. And one of the very first things that was addressed was, hey, so this is a massive point of privilege. We should refer this to the speaker. And the UCP majority were like, yeah, we did say that, but we're going to vote as a majority to just go, nah, it's fine, which they did. And Rocky Pancholi had some very strong words.
It is quite clear that this motion that's on the table right now has nothing to do with listening to the 400,000 people who signed the petition. This motion is on the floor right now because the government needs cover. They need a justification to fulfill the promise that the Premier made to her separatist friends who got her elected as leader of the UCP. And that promise was a referendum. And when they couldn't get the question that they wanted on the floor because of the courts, because of the Constitution and the duty to consult, that is when this government suddenly cares.
That's the reality. And there was a vote, and it was a recorded vote. And we're going to play that vote for you right now, and then I've got some words.
Those of you in the room who are in favor of the motion, please raise your hands.
Honorable Mr. Nixon, Honorable Mrs. Sawyer.
And those of you in the room who are opposed to the motion, please raise your hands.
Ms. Pancholi, Member Ellingson.
For those members participating remotely, please turn on your cameras and microphones if you wish to vote. When the committee clerk calls your name, please indicate whether you are in favor or against the motion.
Honorable Ms. Sassani.
In favor.
Thank you, Mr. Chair. For the motion, 3 against 2.
Right, that motion is carried. Right. Is there any other business under this item? Seeing none, I'm prepared to move us on to next steps. So we are now at the point in the...
Shame on you. Shame on you. Traitors. Traitors. All of you. Traitors.
All right.
He smiles. Brandon Lunty smiles. Gets called a traitor, and he smiles. Now, I got one other thing I want to highlight about Mr. Lunty in the land of authoritarian theater and foregone conclusions, because as I said, this is not the only committee that he's the chair of. And Albertans would do well to pay attention to the other committee that he's the chair of. Because we just finished, like a month ago, I guess, so not just, we did an episode on all of the fuckery that's gone on with the Electoral Boundaries Commission and how the UCP rejected the majority recommendation of the Electoral Boundaries Commission so that they could bust out their Crayola themselves and come up with new maps. And you have to know that I'm about to tell you that the chair of that committee is also Brandon Lunty. So that's cool, I guess. But that's not really who I want to direct my ire to right now in this particular moment. The person who I want to really direct my ire towards is Rajan Sani. And the reason why I want to direct my ire to her is because I have on this show on multiple occasions given her the benefit of the doubt. And the reasons for doing so have eroded over the last year. And I want to talk about that for just a second. In the Kenney days, the story goes that Jason Kenney was very much looking forward to cutting AISH. He was going to roll back the amount of money that people got on AISH. And the story goes that Rajan Sani said, we can't do that. That's not right. It is the wrong thing to do. And if you do that, I will quit. I'm out. I'm not going to be a part of that. I will not support that. That's a powerful story. It's a powerful story of somebody choosing to work inside of a reasonably problematic, some might say, especially since Kenney left, corrupt administration in order to try to affect positive change. But here's the thing. AISH is getting rolled back. Disabled people are being flipped onto ADAP. And a lot of people are actually going to see significant cut in their income. And the criteria that are being used to put people on ADAP are universal. The criteria to get back on AISH are reportedly a lot more limited. Not once have I heard or seen, especially when it comes to voting records, Rajan Sani try to push back against this in any meaningful way. But she's not the minister of those things anymore. She's not responsible to those constituents. I forget, what is Rajan Sani the minister of? Oh, that's right, Indigenous relations. Rajan Sani does a very, very good job of being profoundly performative, especially on her social media, where she talks about the importance of building trust. These conversations aren't always easy, but they are essential. Together, we're listening deeply, speaking honestly, and building the trust needed to drive real progress. The great news for Alberta projects and Indigenous communities: the duty to consult remains in place for any project that may affect treaty rights. That's from this year. Early engagement and meaningful consultation with Indigenous communities are central to this new cooperation agreement. Together, we will ensure projects move forward efficiently while respecting rights, promoting partnerships, and supporting reconciliation. It was a privilege to meet with chiefs from Treaty 8 in BC last night. These conversations are about building respectful, long-term relationships grounded in recognition of Indigenous leadership and governance. By listening to community priorities and expectations around transparency and collaboration, we are laying the groundwork for trust. Today, I was honored to join Premier Smith in the Assembly of Treaty 6 First Nations for a productive meeting and to reaffirm our commitment to collaborate in the spirit of respect and partnership. Well, let's be clear. All of the First Nations across Alberta went to court. They expressed their disappointment, their frustration. They voted unanimously that they did not have any trust in this government. Rajan Sawhney was the last person to vote in that roll call, and she could, in that minute, have grown a spine. She could have stopped the province from being thrown under the economic steamroller that the conversation and the referendum on separation is going to do to Alberta. She could have done all of those things. But no, instead she turned her camera on for 15 seconds to say that she supported the motion that committed Alberta to this course of action. And the reason is gross, and it's simple. And it's Danny had already recorded the video. She'd already bought the airtime. Can't go up against that. I'm embarrassed. Because I'm not saying this from a place of hyperbole. Anybody who knows my story knows that I ran against Rajan Sawhney in 2019. And she gave an award to my wife a couple years later. I was willing and open to okay, well, maybe given the story about the intercession on the age piece, I was willing to be open to the possibility. Maybe Rajan's just trying to do the good thing in the moments that she can. But she not only threw First Nations under the bus while she's spouting off about building trust with First Nations to the folks in BC that she's currently trying to negotiate with. I think we've seen what that's worth. But she threw the entire province under the bus. Now, I want to be clear again. I have no illusions that it would have been very, very easy. If Rajan had voted no, they could have put forward a new motion. They could have put forward a new committee. And they could have forced it through one or the other. Danny could have just done the referendum anyways, because fuck it. But at least somebody in that UCP government would have been able to show a little bit of leadership and a little bit of courage and a little bit of spine. Instead, we got two ministers ceremoniously shuffled off before this vote could happen, presumably because they at least weren't willing to privately stand by it, let alone publicly. This is not respect for democracy, and it's certainly not leadership. And so we got the question. Should Alberta remain a province of Canada, or should the government of Alberta commence the legal process required under the Canadian Constitution to hold a binding provincial referendum on whether or not Alberta should separate from Canada? So it's a referendum on having a referendum, but there's some details to be involved here. And one of them is, that's a lot of words, and it's a very, very long sentence. It's a very, very long. That is one sentence, and it doesn't have a yes or no answer. So it's a very, very complicated one sentence, and it's actually legitimately, demonstrably complicated, because if you run it through the Fleisch Kincaid reading grader, it sets the reading level for the question that is going to determine whether or not Alberta has a binding referendum on separation at a grade 14 level. Its reading level is college graduate, or very difficult to read. That's the question that they brought forward. It's absolutely bonkers. And we're committed to it now. Danny had her little address where she said all the words, and I'm not going to make you listen to any of it because it was a lot of bullshit. It was a lot of spin. It was a lot of, oh, but I love Canada. Listen to my words. Don't pay attention to my actions. The hypocrisy is unbelievable. And the notion that any of the people involved in this shit show have any kind of respect for democracy or people's voices when they're issuing press releases before the vote has even happened. It's not about any of that. It's about the consolidation of personal power, period, end of sentence. And the reality is all of this is happening at the same time that David Parker has leaked the voting records for, by some estimates, the entire province. David Parker had his little Centurion project where he had a database where people could go and they could search people and they could claim them so they could say, I'm going to talk to this person. And it turns out that that database allegedly was from the Republican Party of Alberta, run by former U.S. Marine Cam Davies. I'm not making any of this up, and it kills me. Somehow, David Parker, who appeared on stage right before the last UCP AGM in Red Deer with Cam Davies, somehow David Parker got a hold of the electoral list that was allegedly provided to the Republican Party of Alberta, allegedly. All of this allegedly. The Elections Alberta has issued a statement saying that it's the Republican Party of Alberta list, and David Parker was the one who built the website. But I'm going to say allegedly anyways, because I'm getting sued enough. But if we take a look at the timelines that came from Elections Alberta, April 27th, credible information was obtained suggesting the Centurion Project may be in possession of the list of electors provided to a registered political party that was the legitimate recipient of the list. April 28th, they wrote to the individuals associated with the Centurion Project to advise them that if they were accessing the list of electors, they must immediately cease and desist. April 29th, representative from Elections Alberta, supported by members of the Edmonton Police Service, attended a meeting of the Centurion Project being held in Edmonton to ensure the cease and desist letter was received. Event organizers were again advised. And a copy of this directive was personally served to a representative of the Centurion Project. On the morning of April 30th, representatives from Elections Alberta and Legal Counsel attended the Court of King's Bench in Edmonton and applied for an ex parte emergent injunction to prohibit any further access to or use of the list of electors. The judge granted this injunction, and the Centurion Project is further prohibited from engaging in these extremely serious activities. The injunction has been served. The order directs the Centurion Project and the Republican Party of Alberta to, within 4 days of the order, identify every person or entity. The Centurion Project and the Republican Party of Alberta have provided a copy of the list of electors. Identify every person or entity. The Centurion Project and the Republican Party of Alberta have permitted access the information from the list of electors and provide to the Chief Electoral Officer all contact information the respondents have for these people or entities. And in a shocking twist, David Parker has not fully complied with Elections Alberta, the man who has over $100,000 last I checked in fines for breaking election laws. So there's very good questions to be asked about whether or not the separatists have access to all of the voting records, all of the elector records for every voter in the province of Alberta. But now seems like a really great time to go ahead with a referendum. Why not? What could possibly go wrong? Because Danny used some words, and again, was it actions or words? I forget now. Let's do a little bit more with words before we move on to our last little chunk on this. Because as much as I'm happy to dunk on Rajan, I'm not happy to. You know what? I'm not happy to. I'm disappointed. I am quite frankly disappointed. Because I really did think better of her. But here's somebody that I didn't think better of.
Today, we are beginning the engagement process with Indigenous groups across Alberta and British Columbia to ensure that they can be part of this nation-building effort. That conversation must begin with Indigenous engagement, not as a checkbox, but as a foundation for relationship building, trust, and shared leadership. This will lay the groundwork for full and thorough consultation as this project meets regulatory milestones. To be clear, though, this is about more than just fulfilling a legal duty to consult. It's about working together from the beginning to ensure that we get it right this time, informed by Indigenous perspectives and experiences. We also want to have Indigenous partners at the table as owners to participate not only as holders of territory, but as co-owners of a project and an asset that will provide wealth for First Nations for generations. Our Indigenous Relations team, led by Minister Rajan Sawhney, will develop and lead an engagement plan in collaboration with First Nations across both provinces. You'll hear more details about this from the Minister shortly.
And it is a privilege to be here today at the Assembly of First Nations Special Chiefs Assembly. And I'm deeply grateful for this opportunity to speak to you about the unique relationship that Alberta shares with First Nations. Let me start by saying we acknowledge we are on the traditional territory of Treaty 7 and the Blackfoot Confederacy, and the many First Nations who have lived and cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still with us today, and those who have gone before us. You may be interested to know that we start each week in the Alberta Legislature with a land acknowledgement much like this, right after the singing of O Canada. And we do this because we recognize how important it is for the provincial level of government to be mindful of the relationships with Indigenous peoples in all of our lawmaking. And we recognize the important work being done by AFN to advocate for your members and their communities. This garden and monument are meaningful and heartfelt symbols of Alberta's commitment to reconciliation with First Nations. There were more federal residential schools in Alberta than in any other province in Canada. That's why it's so important that we place this monument and garden right on Alberta's legislature grounds for reflection and for a call to action. Reconciliation is an ongoing journey, and it requires continuous effort and collaboration.
So she can't say she doesn't get it. She can't. She's just a liar. I don't know how else to square that particular circle. She's just a liar. And I'm going to take a quick little, we're going to do a little aside here, because there's a great little thing on our Substack right now. We're going to come back to some more Danny videos. Don't worry, because I'm not done yet. But there's a great little Substack that was written by one of the Breakdown's audience members. That feels far insufficient for the writing that Blaine does, because he does amazing writing. If you haven't checked it out, head over to our Substack, because Blaine sums it up perfectly. Danielle Smith, she becomes whatever she needs to be for whatever the room she's in. If she's in a room separatist, she's a separatist. If she's in a room conspiracy theorist, she'll be a conspiracy theorist. That is what she does. She is made of mercury. And I'm doing his piece a disservice by trying to sum it up. You really should go check it out. And I want to say a big thanks to Blaine for submitting that. As always, we have started the practice of accepting submissions for our Substack for guest op-eds. So just throwing that out there. The email will be up at the end of the show. But before we wrap it up, there's a couple other clips that I want to play. And they're actually from today, because Danny went on, she went and hung out with Vashi Capellos today. And it did not seem to go particularly well for Danny, but she did say some important things that are worth highlighting.
And it feels as though you're trying to say all of these people want to have a referendum, want to risk the possibility of Alberta separating from Canada. I don't understand how that's a fair representation of those 400,000 people. And I don't understand how, Canadians wouldn't arrive at the conclusion that you actually want this referendum to take place, that you are the one kind of driving the bus in that case, because you did lower the threshold. You extended the time by which they could garner those signatures. Like, you made it easier to happen.
Well, I guess the thing to keep in mind is a policy under the old rules, you needed 292,000 signatures, and they got them on both. They got 400,000 on one and 300,000 on another, and combined, it's 700,000 people who went through the process. I mean, it's not easy to go through and set up the booths and get the badges and do the signatures and convince your fellow citizens. So I have to believe that everybody who went through that process and everyone who signed believed what was being told to them, that there would be a chance to vote on this.
And again, that's not what the vast majority of those people apparently believed. That's just Danny saying that they did again. And there's another hard truth that perhaps needs to be articulated here. And that's the reality that just because you work hard at a thing doesn't mean you get what you want. I have no doubts that the separatists who were out in the cold, in the rain, I drove past many of them. I have no doubt that they were working very, very hard. But here's the thing. They didn't follow the rules. And they didn't follow the rules, not through any fault of their own. They believed that they were doing the right thing. They were not able to follow the rules because of the UCP's fuckery with this whole process. Because the UCP moved the goalposts over the field so many times in so many different directions that nobody could keep track of them until a judge said, yeah, we're putting a stop to this. I feel badly for those people who put in all of that hard work. But again, just because you did the hard work doesn't mean you get the thing you want. And the notion that you should every time is bonkers. It's absolutely bonkers. And it's easy to prove, too. There's a lot of people who worked really, really hard for the NDP in the last provincial election. They really, really wanted the NDP to be government. Didn't work out that way. That's just how the system works. And in this case, on the separatist question, the system did exactly what the system is supposed to do. It protected from abuse of process. And in this case, unfortunately, it was the separatists' own people, the UCP, who were the ones who were abusing the process so badly to the point where it was unrecognizable. But that's not the only clip I want to play.
At what cost, though, Premier? And I'm the last person who would dismiss the sentiment that you describe. And I spent all of the last 10 years asking many difficult questions of federal Liberals about their views and the way in which they govern themselves in Alberta. But, you know, there are other ways to address it. And you mentioned them yourselves. You pursue them in some instances with the MOU. Like, the only option is not airing your grievances. And you don't even know if that happens, will it actually end the sentiment? Will it solve the sentiment? The way to solve it, as you've said on many other occasions, is to address what underpins it. Why not do that and not risk the unity of this country?
Well, that's what I have been doing. I mean, the Prime Minister and I signed our MOU in November, but keep in mind the signature campaign for the Remain group was going on all during that time. And then the signature for the other group began in the beginning of the year. So clearly there are some unanswered questions for people. There's clearly is still some frustration. And there clearly is a reason why my fellow citizens want to have this debate. So I don't want to ignore that. I think that the job of a leader is to give an opportunity for people to have that discussion, that debate, and vote on it. And the best way to do that is voting on it democratically and directly, which is why we're putting it on the ballot along with the other 9 questions. I mean, my agenda as a government is the 9 questions we are putting on: to take more control over immigration, to identify 4 constitutional changes we can work towards. And I do want to get a mandate on those as well. But this is something that the citizens have been asking for. And so we'll put it forward, and I will make the strongest case I can that things have changed and that it's time for us to work together on the issue of Remain and to make Canada stronger.
Let me be crystal clear. Leadership is not doing what a minority of people tell you to do. That is, in fact, the opposite of leadership. Leadership is when you are able to set your sights on a goal that is hopefully for the better of all of the people that you're ostensibly leading, and you're able to convince them through your words and your actions that that is the goal that you want to achieve. And here's where it gets problematic for Danny. if you take a look at her words, whether it's going all the way back to her leadership race, when she sung the praises of Dr. Dennis Modry and how he was her plan B if the federal government didn't give her everything she wanted. If we take a look at her Sovereignty Act, if we take a look at her demonization of judges, if we take a look at her actions, where she has constantly lowered the bar for the separatists, she can say that her goal is to be the new Captain Canada. But her words and her actions combined paint a very different picture as to what her goal actually is. And this is something that she should absolutely have the stones to take responsibility for. If you're going to be a separatist, I disagree with you, but to hide behind your constituents when you have deliberately, over years, manufactured a set of circumstances is some level of cowardice that I don't know that I've ever seen on the provincial stage before. But when you think about it, it all makes sense.
This is huge. Like, to be blunt, to everybody watching, this is hugely consequential. It was for Quebec. It was for Canada back in 1995 and in 1980. In fact, Quebec's economy has never recovered. In this case, not only did you change the law, you've had so many off-ramps. You could have used the court case as an off-ramp. You could use the fact that we're in a trade war with the United States as an off-ramp. You could say, I never campaigned on this in 2023, so it isn't democratic for me to go ahead with it now. But you're not choosing any of that. You are very distinctly risking your province's economy and perhaps the larger Canadian economy to put this question forward. Is it to do, as Doug Ford said today, just appease the 30% of your base that wants this?
Well, direct democracy is the ultimate form of democracy, and that's what this is. It's an exercise of direct democracy where every one of the Albertans eligible to vote will be able to have their say. And my view is that you don't just eliminate the anger that people have by ignoring it. I think if you try to ignore it or suppress it, it can grow into something out of control. I think this gives an option for people to be heard, and it gives an option for those who want to remain, those of us who want to remain, to make the arguments about why we feel so strongly about that. I think it would be far worse for this to linger on for years, creating more and more division, more and more frustration. I think that we have 5 months now to have it out, make the case, and be able to vote on it and move on. And I hope that the result that on October the 19th is to remain, so that I could get to work on continuing to build the case for Alberta within Canada, and to build a case for some of the issues that I think have caused that frustration, and to resolve them. I think we've got a Prime Minister who's now prepared to work with us on that, and I think that's positive. It's not just positive for us, it's positive for the whole country. I think that there's a lot of frustration with the way that the government conducted itself over the previous 10 years, as evidenced by the fact that the Prime Minister was removed, and the leader of the official or the opposition that was supporting him with the NDP was also removed. I think people want to move on, and I think we have to be able to have that vote, have a robust debate, make the case, and be able to convince our fellow citizens of that there's a reason to fight for Canada and to make it work.
It's been a lot more than 10 years. We've already demonstrated that in this show. But it really comes down to the fact that Danielle Smith does not believe in Alberta democracy. She doesn't. Alberta is a representative democracy. Danielle Smith believes that a representative democracy is inferior to direct democracy. She literally just said it. Direct democracy is the ultimate form of democracy. And she's apparently willing to throw under the bus all of the people who are not part of that majority. And she's taking a hell of a gamble with this whole situation right now. Because it seems like her hope is that the separatists will be in the minority. But if that's the case, she's rolling her base. If the separatists are in the majority, then she's rolling the rest of the province. And it doesn't have to be a majority of the people who actually believe these things. It just has to be a people who show up to navigate the essay question and cast their vote. There's a principle And it's a very basic principle. When you're confronted with a situation that you don't know what to do, and both outcomes or all of the options that are available in front of you have the potential to cause harm, it is an ethical and moral principle to choose the one that causes the least harm to the least number of people. By Danielle Smith's own admission, the separatists are a minority. If she doesn't give them their referendum, maybe she doesn't get to be premier anymore. But the province is saved from an economic steamroller, as is the country. That would be, to a reasonable person, the best choice possible. But this is where it gets down to that same core that we've addressed on the show many, many times before. Danielle Smith has spent her entire career desperately trying to get to the cool kids table. And she desperately wants to get to the cool kids table and stay there because she needs that attention. She needs that excitement. And that might actually be her downfall. Because one of the safest ways to remain in government, to remain in an elected position, is to minimize the drama, to do a good job, to make it so that people don't have to pay attention to whatever fuckery you're up to, so that they can take the kids to baseball, so that they can go do all of the things that they want to do. But instead of keeping government boring and quiet, Danielle Smith, because she wants attention, she wants to be the coolest kid at the cool kids table. She wants everybody to like her. She's made politics very, very, very not boring. And that could very easily be her downfall, because mistake after mistake after mistake just keeps happening. And because she doesn't have the ability or the people around her to say, we need to stop, this is getting out of control, because she lacks that internal mechanism in herself, and because she does not have the people around her who are able to communicate that to a way and that she's able to hear it, Alberta is now facing a referendum on separatism. That's where we are. We got to get in the game, folks. I cannot stress enough that we cannot sleepwalk our way into Alberta's own Brexit. Because we'll lose. We're not a country. We're not England. The legal mechanisms that need to happen in order for Alberta to leave don't really even exist. And the separatists will try to tell you a bunch of things about, but there's this and this. But it's always viewed through one lens, looking at only one side of the whole picture. And it's easy to disprove. What are the things the separatists? You can't landlock a state. If we're our own country, there's this UN convention that says that we're allowed to have pipelines. Bad news, guys. We've got pipelines. Nowhere in that UN convention does it say, and then you get more. But we're not thinking about that. We're not talking about that. We're only looking at one side of the object that we want to see. It's the people that haven't heard this stuff that people need to be talking to. The tagline of this show is keep the conversation going. For the next 6 months, we need to be getting the conversation started. And this is where I want to say one last little thing. Do not, unless you want to, for fun or sport, don't waste your time trying to change separatist minds. It's not worth it. You're not going to get anywhere. If they're going to come to the conclusions that what they've been fed is a falsehood, they're going to have to come to that on their own. But the problem that exists is, for so many of these people, it has become an issue of identity. And shaking people from an issue of identity is one of the hardest things that you can do. And it doesn't make any sense to waste any time engaging with anyone who wants to get into a bad faith argument about why you should believe that separatism is the greatest thing since sliced bread because a guy who ripped off his family to the tune of $1.2 million and another guy who ripped off First Nations says it's a good idea. You're not going to get anywhere. The people that you need to be investing your time in and talking to are the ones that haven't had this conversation yet. And we need to make sure that you and they and everybody else show up to vote. Because that's the ball game now. This is real. This is happening. Danielle Smith has allowed a 5-alarm fire to occur on her watch because her only instinct is to preserve herself. Decisions are made by those that show up. You got to believe the separatists, boy, they're going to show up. And we got to make sure that we show up and double their numbers. Otherwise, Danielle Smith is going to continue to Danielle Smith. And with that, I told him, I was like, show will be an hour and a half, 2 hours in. But I have some exciting announcements that I want to share before we call things a night for tonight. First of all, yes, new start time, 7 o'clock. We're doing a 7 o'clock start time. There's a bunch of different reasons for that. Mostly is I'm told that I should be getting some sleep at some points in time. And when the show goes till 10 or 11 o'clock and I have a morning shift the next day, it's not good. So 7 o'clock start times going forward. If you're just finding that out now, sorry, we posted it in a bunch of places. You can just hit the little bar on the button and go back to the beginning because I was on fire tonight. That's the first announcement. But wait, there's more. We're going to try a new thing over the summer. Because here's the thing. I miss the call-ins. I really, really do. And one of the byproducts of this unmitigated dumpster fire that has become Alberta politics is the conversation piece that used to be such a big part of this show is not a thing anymore. And I want to get that back. And so we're going to try something to see how it works. And what we're going to be trying is on Thursdays, every second Thursday, we're going to do it Danielle Smith radio show style. Every second Thursday at 7 o'clock, we're going to do an hour where I'm not going to be presenting any information or issues. We're going to do straight up call in. We're probably going to have to do it through the Twitter Spaces to start with because I still haven't figured out the other things. But Thursdays, every second Thursday, we'll make the announcement for the first one. I suspect it will probably be not this, but the 4th of June. That will be our very, very first one because it gives us some time and me some time to get a run up at it. So that's exciting. I'm excited. I hope people show up for that because if it's just me for an hour waiting for somebody to call in, that would be sad. I did see somebody in the chat earlier asking how do we go about asking questions. That's how. One of the other ways that you can ask questions if you want to is you can send the emails and the DMs and all of that kind of things. But I'm so excited for this. Especially because I already know who some of the guests are. Edmonton, what's up? We're coming back. July 25th. I'm so excited for this. We're back at the Orange Hub Theater. I really like that space. I really like that room. And we're going to be doing another live show, July 25th, 7 p.m. it's scheduled to 9. I've booked the room for later because boy, did I learn my lesson last time. Tickets are now available at Breakdown AB Live. Little thinger there. We do have, if you somehow missed we have a special discount code for our Patreon supporters. And we do have a special pricing for folks who are on ADAP, because it will unfortunately be ADAP by then. Because we do want to try to make it accessible for folks, but save the date. And let me tell you, oh boy, some of the guests we have lined up, it's going to be timely. It's going to be topical. I'll tell you that right now. But the caliber of folks that I get to share a stage with, I am so spoiled. And this is going to be a conversation you don't want to miss. We will be doing a show in Calgary, probably in August, later August, as well. But this one is locked in. It's not during Fringe. I learned my lesson. I'm very excited. So get your tickets now at the breakdownABlive.ca. And now come the rest of the plugs, because you can also get our merch. We have all of our merch available at the breakdownabmerch.ca. See what we're doing here? We got a little bit of a theme going on. You can get the t-shirts, the hoodies. Summer's coming. You can get yourself a tank top. You can get yourself a hat to keep the sun off the things and the stuffs. And then, as always, we also have all of our support stuffs. So if you want to be a Patreon supporter and get access to that little discount, every little bit helps us to be able to do the things that we do, and we do have some more exciting things planned as we continue to try to grow as a little show. You can sign up to be one of our Patreon supporters at www.patreon.com/thebreakdownab. If you're not into the recurring long-time commitment, then you can always send us an e-transfer at info@thebreakdownab.ca. Everything goes towards helping all of the things that we do. So that's the show, folks. I want to thank everybody who has tuned in tonight. We had some good numbers show up tonight. Thanks, y'all. That was pretty fun. And if you appreciate the content, okay, so here's what I made the mistake of clicking on the chat. Yeah, I'm wanting to do rural Alberta as well. I'm just looking to find the venues. I need a little help with that. So if anybody has like a little theater in your community or a community hall or something where you think you might be able to get a few people together and I can come out and we can do a thing, send an email. I am so up for that. Because I've said it before, I'll say it again. I grew up in rural Alberta. There's a big part of my heart that's rural Alberta. So there's that. And I think that's it. I think that's everything. Oh yeah, May 29th, the Alberta Day of Action, compliments of Gil McGowan. If you didn't catch the interview that we did with him, well worth checking out. He's bringing a little bit of things to bear. Got a couple interviews coming. Very excited for them. Yep. All right. That's it. I want to say a big thank you to everybody in the chat for chatting. It's so good to I forgot how much I missed the community part. There was a bunch of interview episodes, and then there was the attempt at a break. Sorry, that'll never happen again. Yeah, there's all that. So thank you all so much. Do the likes, the subscribes, all of that. And with all of that being said, oh, don't worry, I didn't forget.
How's your BS detector evolved over time?
I tend to be pretty trusting.
Yeah, I didn't forget. Thank you all so much. We will see you next week. It will be a live show because it's going to be every Sunday. We're doing live shows again. Yeah, in the meantime, take care of each other. Be kind to each other. Don't talk to separatists or try to change their minds anyways. You can talk to them about I don't know, the weather or cheese. But don't try to change their minds. Try to inform and better change other minds and keep the conversation going.